Welcome to the first online group meeting of this year. I'm happy that we have quite an audience for the speakers. I would like to start quite quickly because Ram, one of our speakers, has an engagement with the CCI now and couldn't change this. So we will switch the order of the presentations. Will Much from Arnold and Porter was so kind to allow that we will switch. So Herman Gini and Ram from Indian member from AZB will start with their presentation on news developments in India, and maybe you can briefly present yourselves to all of us. It's your floor.
Thank you. Thanks, Harold. Thanks, Will, for accommodating the last minute request. To everybody, pleasure meeting you. I am Ram Kumar. I am a partner with AZP, and I have my colleague Himangini, who will be speaking shortly in a few minutes. So we'll be presenting about recent developments in India. I'll touch upon some of the interesting developments in the antitrust space, and my colleague Himangini will talk about some recent developments in the merger control arena. The first point that I would like to highlight is that there is an interesting change in the way the CCI has been approaching information exchange when it comes to cartel enforcement. The Indian Act does not expressly prohibit information exchange. It does not explicitly state that information exchange is illegal. What the law states is any anti-competitive practices are prohibited. All cartel activities are prohibited. When it comes to information exchange, there is a certain, let's say, a silence in the legislation. In this context, the CCI has been kind of slightly changing the way it has been analyzing and approaching information exchange. In the early years of enforcement, between 2009 to 2012, CCI used to look at information exchange plus price parallelism to kind of draw a conclusion of contravention of the act. But in between, somewhere in 2017-18, there were a handful of orders wherein the CCI said that if there is going to be information exchange without any action taken on implementation of information exchange, this would not be a contravention under the Competition Act, which was a bit of a bizarre result or a bizarre outcome. We were quite surprised at that point in time. But now, in the recent 6 to 8 months, the CCI has passed two interesting orders, one against beer manufacturers and the other one pertaining to a paper manufacturers. In both these orders, they've in some sense reset the threshold. The CCI has clarified that a simple exchange of information without any action has an impact on the competitive climate and landscape in the said market, and therefore it would be a violation under the Indian competition. So this is one interesting development. And the second update or highlight that I would like to bring to the notice of our friends here is that like authorities in other mature jurisdictions, the CCI continues to enthusiastically pursue tech and digital companies. In the last 12 to 18 months, the CCI has passed almost 10 to 11 initiation orders against tech companies. And more importantly, the CCI consistently has taken a view that they are interested in data-related competition law violations, right? This was first, CCI made it very clear in the WhatsApp privacy case, where they said CCI does have jurisdiction and the power to look into data-related competition law violation. In that case, the matter went to the Constitutional Court, the Delhi High Court, and the Delhi High Court also agreed with the CCI that CCI has the power to look into data-related competition law violation. The CCI has now, in some sense, been emboldened by the Constitutional Court agreeing with the CCI. And in the recent findings that it launched pertaining to a market study that it conducted in the pharmaceutical space, in one of the portions, they've mentioned about the role of online pharmacies, right? In that section, the CCI has tried to plug in the larger data agenda by saying that we are mindful that these online pharmacies collect significant amount of sensitive data, and we will have a watchful eye and understand as to how this data is being used by these pharmaceutical players. So while globally authorities are a bit circumspect about this data point, right? There's been like conflicting views, but CCI seems to be quite interested in the data related point and has been very vocal in establishing its authority to look into data related violations. The last update on the antitrust side would be the competition amendment bill is now before the Indian Parliament. As some of you would recollect, this was introduced in the Parliament a couple of years ago, and it couldn't go through the motions within the Indian Parliament, and it had lapsed. And this is now being reintroduced. And the popular expectation in India is that this time it should kind of get through the process, and in a matter of weeks there might be the new amendment in place. I would just want to take a minute to kind of recollect the most important aspect. The amendment now introduces provision for commitments and settlement, which will be a game changer when it comes to competition law enforcement in India, because that's one of the biggest and the most important addition to the amendment. That's all from me. Over to you, Himangini. Thank you. Thanks, everyone.
Great. Thank you, Ram.
Are there questions right now?
Just if I may, a brief comment on the topic of exchange of information. It's a compliment. It's interesting to hear what India is doing. We have a brand new case involving exchange of information in the HR, the human resources area, amongst HR professionals. And this has been a huge breakthrough, just exchange of information. So no poaching agreement, no wage fixing, just exchange of information, benchmarking type. Which also shows the agency worried about that kind of thing. It was a huge surprise for most people. Over 60 companies, more than 100 individuals being prosecuted, being treated like a cartel. So sort of like India, stepping up enforcement against exchange of information, even without any hint of an agreement in that regard. That's an interesting development to see parallel in other areas.
That's very interesting and useful.
There is one more thing, if I can add, if I'm permitted to add, sir. The President of the Chair, can I add one more interesting?
Yes, sure.
Thank you very much. Thanks you, Ram, for giving the recent analysis. But I'll just add one thing. The CCI has now started looking at the naive cartels a little differently. There's a new trend of not imposing a penalty despite finding a cartel. And this is something which is peculiar to perhaps India or maybe developing jurisdictions. There are cases, number of cases, and this is not one case, there are a series of orders which the Commission has passed, whereby it has held that there is a cartel. There is plenty of circumstantial as well as direct, even direct evidence in the form of exchange of WhatsApp messages and what have you. But still the CCI says fine, because it's a COVID time. Taking that into account, they have stopped giving penalties. They say we are just giving a cease and desist order. But what happens in this process, some of the bigger companies also get the benefit. In fact, I wrote on this also that the naive cartels are being discovered in India in a different way. So that's I want to add something. So, and of course, you may be aware of the Amazon's suspension, of the approval granted. There's another interesting thing. So Amazon and Apple and Google, GAFA is facing heat, like elsewhere in India as well. I mean, that I sure Ram would have mentioned. This unfair,
Okay.
which is just unprecedented, which has happened in the case of Amazon. Something that was granted 2 years back, they withdrawn that and suspended that approval, and they also imposed a penalty on that. So
Okay, thank you.
Thank you very much.
Thank you very much. Hermangini, it's up to you right now.
Oh,
Maybe
thank
we
you
can
very
collect
much,
questions.
Harold.
Yeah.
Thank you. Hi, everyone. Pleasure to be here. I'll be taking over the merger control update from India. Just to introduce myself before that, I'm Himangini Dadwal, also a partner at the competition practice at AZB and Partners. A much shorter update, I think, from a merger control perspective. I think the most significant one is that we have a target-based exemption, something that is common, I think, in several jurisdictions where acquisitions or mergers involving a small target, and a small target is defined as an entity with assets of less than 46.8 million USD, and or turnover of 133 million USD. So this target-based exemption, which has been quite useful in benefiting, transactions by big entities, primarily in the digital space, have been able to benefit from this exemption. This exemption came in 2017, and it's due to lapse in about a month or so, 27th March to 2022. This particular exemption has been in force every 5 years, starting, I think, back in the day in 2011 or 12. So we do have an expectation that this will continue. But as my colleague Ram had previously mentioned, that there has been great scrutiny in the digital/online market, it's possible that this particular exemption that currently exempts acquisitions or mergers into a target that has either assets of less than 46.8 million in India or a turnover of less than 133 odd US million dollars in India. So it's an or test. As long as the target in which the acquisition or involving the merger generates turnover in India that's less than less than the threshold, or has assets that is less than the threshold, would not need notification to the CCI. There could be certain changes that are expected. For example, potentially there is some discussion about how the target needs to be below both thresholds now, that in terms of both turnover and assets, it should be less than the de minimis thresholds, as it were. So we'll keep this group posted, of course. Now, 27th March is when it's the expiry of this exemption will take place unless renewed. We don't believe that it won't be renewed, but we do expect there to be certain changes, because as everyone knows, the digital markets, especially these the slightly more critical players in the digital and online space, they usually don't have significant assets, so they benefit from the de minimis exemption. And the thinking right now is that the scrutiny needs to be on these players. Killer acquisitions is something that's high up on the agenda of the Competition Commission, as like much of the world. So we will, of course, keep the group posted on whether this is extended, and if it is, then what are the changes, if any. So that was on quickly on the de minimis/small target exemption. Very recently, also, and this is something that's more of an evolving concept. That's something to speak about, the definition of control. So as most of this group probably knows, is that India followed, much like the EU, the decisive control test previously. Control is, of course, an important concept for merger control, because one of the triggers for notification is the acquisition of control. There are also certain exemptions, such as the intra-group exemption, that will benefit from the definition of control, depending on how that's taken. And most importantly, the group thresholds, because control happens to be an element of what the CCI considers to be a group. An expansive definition of control or a narrow definition of control really determines on how those broader jurisdictional thresholds are considered for the purposes of computing your assets and turnover. Unfortunately, over the last 2 or 3 years, the decisive influence test has been watered down significantly by the CCI to make it more of a material influence test. What does that mean? Effectively, the view that the CCI has taken is that a board seat that is granted, along with certain affirmative veto rights or affirmative voting rights, even on certain strategic items, And this may come as a bit of a surprise. Certain strategic items are not only things like, engaging in a new line of business or discontinuing a business or, appointment of key managerial personnel, but equally things like amendments to charter documents, appointment of statutory auditors, several items that would not have or otherwise in several other jurisdictions been considered key strategic items. So just to maybe take you through some of the items that have been considered as control conferring by the CCI very recently is appointment or change of auditors, discontinuing an existing line of business, changes to constitutional documents, changes to capital structure, incentives, and so on. Just having a board seat with one or two of these rights, or even having an observer seat, regardless of whether it's a participating observer or a non-participating observer, has more and more nudged the CCI into taking a view that this would be control conferring. This means that when I'm computing, for example, what constitutes a group to determine whether jurisdictional thresholds in terms of assets or turnover are met, the CCI will consider more and more entities within the group, depending on the diluted test of control, to qualify for, to determine whether or not those jurisdictional thresholds are met. Another implication would be that when I'm trying to benefit from the intra-group exemption, because control happens to be an element of what the CCI considers as group, you may not benefit from something as simple as an intra-group exemption. And finally, and this is the third update that I had, and we can maybe quickly touch upon on Mr. Sharma's update on Amazon's suspension of the approval, is the implication on what is considered as a common minority ownership. So if I'm a PE investor, and typically I would, of course, invest in several entities within the same sector, typically, because that's my area of expertise, I would have several entities in India where I have minority shareholding. The CCI has, in a recent decision, not so recent anymore, it's about a year old now, taken the view that in the pharmaceutical sector, it was Chris Capital that had shareholding in about four or five different pharmaceutical companies, had less than 10%, less than 20%. In some had just a single director with a very small limited set of veto rights. In some had just an observer with even less veto rights, was going to acquire about 6% shareholding in another target enterprise. The CCI took the view that because of this set of minority investments that Chris Capital already had, and because the kind of shareholding meant that it had control because of the diluted material influence test, simply by having a board seat and one single board seat and a few other AVRs, it had control over a bunch of pharmaceutical companies in what is considered a pretty sensitive sector in India. And so decided that firewalls was not enough, but directed that Chris Capital divest its board seat in one of the companies and undertake not to exercise certain rights. Increasingly, this is the view. So I think what perhaps when advising in India, one needs to be conscious of is to have, of course, firewalls is essential, but equally to be a little careful in how you're negotiating the agreements. If you only want to, if your client is only interested in having a passive in financial investment, the kind of rights that need to be sort of examined from that perspective become all the more important from a CCI perspective. So I'll pause there. If we have time, Harold, and I completely defer to you. I know there are a couple of other people who are speaking after me. We can quickly touch upon the Amazon decision, but which has been making the news. It is a one-off case. I think there are a lot of other factors involved. The Supreme Court, the High Court, a lot of politics involved in this decision. So I'm not sure whether it's entirely antitrust related, but we can certainly touch upon that if we have time. But I'll pause there.
Yeah, I think we first should have the talks of the others, and then at the end we can see whether this is feasible. In addition, digital markets and activities might be the topic of a future online meeting, because this is coming up more and more often. So I think that is more effective. I would like to make just one remark. When you talked about the definition of control by the CCI, I think that it is very important, and you all will know this, that the definition of terms like control may differ from jurisdiction to jurisdiction. And so we may not draw the wrong conclusion that if the European Commission would not consider something as sole or joint control, that using the same term, another authority may define this in a different way. But this is, I think, evident. I would like to allow just one question regarding India, because we are now 24 minutes in the talk already. Is there an urgent question right now? So if not, I would like to welcome all those people who are attending such type of group meetings for the first time. There was no time at the beginning because Ram had an engagement coming in with the CCI very urgently, and I wanted to make sure that he can then run away to do this. When I'm welcoming, and at the end of the meeting, we may briefly mention the plans for the group next time. When I welcomed new participants, I would now like to welcome an old friend of the group, Will Mudge from Arnold and Porter. He was a speaker of a client event at the World Law Group Spring Conference in Seoul in 2011, so 11 years ago, I think. Now we have you again. Everybody knows Arnold and Porter. I think I do not need to present the group, but maybe Will, you want to talk or mention what you are doing? It's your floor.
Thank you very much, Harold. I hadn't realized it was 11 years ago. It doesn't feel that long. But it's great to be back addressing you, and I should be doing it. I should be with you more. So yes, I am with Arnold and Porter in Washington. Don't be fooled by my virtual background. I realized I didn't have one for Washington, so I'm not, in fact, in San Francisco. And I'll be giving an update on U.S. competition law developments and policy developments. I try to keep it at a fairly high level and focus on policy and personnel changes, and somewhat on merger control, as I think those are probably the areas that would be of greatest interest to this group. However, our firm recently completed a series of 3 one-hour webinars in the last several weeks, one on recent developments as sort of a 2021 year in review, one on merger control, one on litigation, and one on criminal antitrust enforcement, all of which are specific to the US. Those are all available on the Arnold and Porter website. And if you go to my bio under the perspectives tab, you can find all 3, even though I was only a panelist in one of the 3. So if you have trouble sleeping, and you want to watch something, you know where to find it. So on to the substance a little bit. I wanted to start just by emphasizing, and I apologize if this is something folks are already aware of, but it's pretty important. The Biden administration has really emphasized competition law and antitrust policy in a way that made it a part of the domestic policy and given it a prominence that we have not seen in a long time, really ever in my 25 years or so of antitrust practice. And he's trying to take what he has referred to as a whole of government approach to antitrust, which it means that all agencies, including not just the FTC and the DOJ, the traditional antitrust enforcers, are sort of directed to consider their implications of their decisions on competition. And this emphasis was reflected in the people that he's chosen, which I'll talk about in a second, to lead the agencies, the antitrust agencies, but also there was an executive order last summer, the president's executive order on promoting competition in the American economy, which laid out 72 specific initiatives that are directed at promoting competition, and these range from sector specific studies by various agencies to directing different federal agencies to consider rulemaking, and we'll talk about some of that. The executive order singled out big tech and dominant internet platforms, as that's really no surprise, given particularly, that's a worldwide phenomenon, as Harold mentioned. And they identified several areas warranting closer scrutiny, including acquisitions of nascent competitors, aggregation of big data, surveillance of users, and network effects. But there are also industry-specific provisions and directives in there to direct the antitrust agencies and other relevant government entities to look at sectors like pharma, agriculture, telecom, alcohol beverages, transportation, really a whole gamut. So it's really something that's different from what we've seen in past administrations. And I should mention the executive order also included a directive to the FTC and DOJ to look at whether the merger guidelines needed to be, horizontal and vertical merger guidelines needed to be updated, and that is ongoing. And I'll talk about that in a little bit. The executive order also established a White House Competition Council within the executive branch to coordinate interagency activities, including independent agencies like the Surface Transportation Board that governs railroad mergers, the Federal Reserve Bank System, et cetera, and asking them to consider market power issues and when reviewing mergers and making decisions within their purview of authority in their industries. So I mentioned leadership and appointments. The folks who are being appointed to head up the antitrust agencies really have a much more aggressive, some would say progressive, some would say aggressive way of thinking about antitrust enforcement. Jonathan Cantor was confirmed in November to lead the DOJ antitrust division. He's a longtime agency lawyer and law firm partner, longtime practitioner, well known for his critiques of Google. And then probably most famously, FTC Chair Lina Khan first rose to prominence based on an article she did as a student in law school, addressing how antitrust thinking and enforcement was unable, in her view, the current thinking to address anti-competitive activity by Amazon. So she was nominated as an FTC commissioner, is now elevated to chair, and we'll talk about some of the things the FTC is doing. There's a commissioner who's pending Senate confirmation named Alvaro Bedoya, who's a professor at Georgetown with a specialty in digital privacy and data. So he's, that's consistent with a consumer, pro-consumer focus in the privacy space. And then they've appointed another similar kind of progressive antitrust scholar named Tim Wu as special assistant to the president in the White House on this topic. And these individuals believe in a new sort of antitrust theory, or a different antitrust theory way of thinking than the Chicago school that's been kind of the dominant theory in the U.S. way of thinking about antitrust for some time. So there's less emphasis on consumer welfare, which has been the standard governing how people think about whether something should be considered anti-competitive under our antitrust laws for decades. They're more in favor of, or more focused on, preventing predatory behavior by dominant firms, more pro-government intervention, more skeptical that market forces will generally constrain companies' competitive behavior in ways that protect consumers, and this is really playing out in already, even though it's been relatively recent that some of these folks have been in position, and it's already playing out in their approach to mergers, mergers and acquisitions in particular, but it will resonate in other areas going forward as well. So there is already an overall more skeptical tone regarding mergers and acquisitions. A lot of complaints about the volume of mergers that the government has to review and the lack of resources to do that. There's about a year ago, I believe, the FTC suspended early termination of Hart-Scott-Rodino waiting period. So that, as you probably know, the waiting period is the initial waiting period is 30 days unless you receive a second request or are asked to pull and refile. But you could always receive early termination if a transaction really posed no antitrust concerns. That has been suspended and remains suspended. So nobody's getting early termination, even for deals that are manifestly not raising antitrust issues. Second requests, that document and information requests that extend the waiting period are becoming more frequent and broader in scope. And as I mentioned, new vertical and horizontal merger guidelines seem to be likely to be forthcoming. The FTC has already announced that it will not be following the 2020 version of the most recent version of the vertical merger guidelines. And seemingly the DOJ will be acting similarly. And both agencies have put out a solicitation for public comment on merger enforcement to guide development of new merger guidelines, which I will refer to in more detail in a second. In the meantime, we're seeing, more the agencies considering different theories of harm than they might have considered in the past. More focus on monopsony power, particularly in labor markets. More focus on vertical issues, consideration of impacts of transactions on narrow groups of consumers, and basically just a whole re-examination of whether the merger review process needs to be more aggressive with regard to things like nascent competitors, acquisitions of nascent competitors, as I mentioned. To talk a little bit more about some of the specific developments that we're seeing, and again, the FTC leadership has been in place longer under Ms. Khan, so some of these are kind of focused on the FTC, but they have been requiring more information up front before modifications to a second request are granted. So when you receive a second request, you negotiate with the government about what you really have to produce in response to this very voluminous request. They want more information up front before they will grant you relief from some of the requests. They have adopted a resolution that allows the FTC to issue compulsory process, CIDs and second requests without a full commission vote. And it gives the chair even more power, more control over individual investigations. The FTC's been issuing what they call close at your own risk letters. So when the initial waiting period expires, if it's not being extended by the issuance of a second request, they have been issuing sometimes, not in all cases by any means, but letters that basically warn the parties that if they are closing at their own risk if they choose to move ahead and close, and reminding the parties that the agencies can review mergers that have already been consummated. That's always been the case. It's just sort of a warning, sort of a shot across the bow type of letter. So it's unclear exactly what sort of practical effect that has, if any, but it's indicative of the level of intensity or aggressiveness in terms of enforcement. Another thing worth noting is that when mergers are, when concerns about a merger are resolved by consent decree, by agreement with the parties, the FTC is going back to um, prior approval provisions, which used to be a feature many years ago of these consent decrees, where they write into the agreement that they will get to review additional future acquisitions in the same space and sign off on those, even if those transactions would not otherwise be reportable under the generally applicable merger control Hart-Scott guidelines. There's also, I mentioned the merger guidelines review project. The agencies in about mid-January put out a notice for public comment soliciting input on what might need to be changed about the merger review guidelines that are very broad, and they cover a lot of different topics, including just the fundamental purpose and scope of merger review. And, you know, how horizontal deals should be thought of differently than vertical deals, whether there should be certain presumptions that certain market circumstances justify a presumption of anti-competitive harm, such as based on concentration. So whether thresholds need to be changed in that area. Updates on the approach to market definition, whether the guidelines need to address specifically threats to potential or nascent competition in a different way than they currently do. Impact of monopsony power. I mentioned labor markets. That is a theme that is cut across Biden administration antitrust policy, being concerned about labor markets, and that includes in the criminal space as well. No poach and wage fixing, actual criminal cases there in instances of alleged collusion. So there's that process is about a 60-day comment period. So we will see continued movement, I'm sure, on that front, as far as developing new, proposed merger guidelines. So that is, I've covered a lot. There's a lot going on. I haven't really gone into any, litigation or criminal enforcement other than that, just that last comment about labor market stuff. But I realize I think I've probably done in my 15 minutes or so. So I'd better pause and see if there are questions or comments.
Yeah, thank you, Will. Are there questions? No questions.
Many questions, actually. There are tons of things.
Too many, probably.
Just one.
No, we're talking about a potential revolution, but we are all wondering whether that's going to translate into practice or not. As you said, you're talking about changing assumptions that are so basic. Okay, the presumption would be mergers are anti-competitive in certain circumstances, and it's up to you. The burden of proof is yours to prove otherwise. But I'm wondering, you have the courts in the US also as a driving force, and they have not changed, and they were packed by Trump and other administrations in the past. How much will they resist any change by the administration to try to revolutionize thinking? And in practice, what does that mean for companies?
Yeah, that's a very good point. So I think you have identified the question exactly right, and I think it is not one that we can fully answer right now. I do think you would expect that the courts will not have changed their thinking sort of overnight the way the leadership of the agencies are trying to do. And so you would expect resistance to anything that's sort of particularly novel. And that's going to vary to some extent based on the individual judge that you get. And I guess I would say with respect to merger control in particular, I mean, we have some vertical mergers playing out now that are being challenged in the courts as well as horizontal. So there's definitely a handful of cases in the courts on mergers right now. And, that'll be a good series of test cases, although I don't know that any of those theories are sort of particularly radical. The theories that the government is challenging those deals on. One interesting thing in that regard is I mentioned the collusion, the labor market collusion criminal cases. We do have some very recent decisions on motions to dismiss in a couple of those cases where the defendant said, no one has ever gone after no poach agreements or even wage fixing criminally in the past. So it's not a per se, the defendants argued, not a per se unlawful offense, therefore it shouldn't be criminal, can't be criminal. They raised constitutional arguments about fair notice, etc. And the courts so far, there's just 2 decisions in there within the last month or so. But the courts have basically gone along with the government to say that those types of that type of conduct can be criminal, and they haven't been convicted yet. But the defendants have lost motions to dismiss on those issues. So in those instances, the courts are going along with the agencies. Not really quite the same thing as fundamentally changing an approach to merger control, but it's sort of an interesting development.
Mm-hmm.
Okay, thank you very much. Unfortunately, there never is enough time to discuss all the questions. I would like to make sure that Ricardo also has his slot to present the newest developments in Portugal now. Thank you, Will, for your presentation. And if you are not able to sleep during the night, as Will said, then go to his bio and you can look into the videos done by Arnold or Porter recently. You said when we are not able to sleep, this reminds me of Russell Miller from Australia, who just sent me an email that he cannot participate now as it is 1 o'clock in the night for him. So for the last presentation of today, I would like to hand over to Ricardo for the developments in Portugal. It's nice that we can combine here reports on the Americas, on Asia, and finally Europe. Ricardo, the floor is yours.
Thank you very much, Harold. I think that I will be shorter than the previous interveners, in order to allow for some time for questions in the end, if people have them. So what do I have to say in relation to Portugal? First, that the competition authority has remained extremely active. They've now crossed the threshold of 1 billion in total fines since the authority was created back in 2003, with a big chunk of this amount in the last few years. So the authority has been very active and has definitively moved into a new paradigm in terms of their level of activities. We've had over 100 million in fines imposed last year, with the PCA taking decisions in a number of cases, in particular in one very large investigation that they have into the modern distribution sector, which is something we are following very closely, and of course we are also active there, in which the suppliers and retailers are being accused of hub and spoke practices, and as you know, there is quite a bit of doctrine on the matter, but at least at European level, very few precedents of application of this legal figure, which is arguably something not easy to demonstrate, and so we are looking forward to see what the first court decisions on these matters will be. As a result of this great activism by the Portuguese Competition Authority, I would say of all the developments, the most important one is that private enforcement has literally exploded. We've had in just a little bit more than 1 year class actions in an amount over 1 billion that have been filed. Some as follow-on decisions, follow-on claims from decisions from the Portuguese Competition Authority, but also follow-on claims from decisions adopted by the European Commission. We have cases against Daimler and Fiat Chrysler regarding the process on devices that allegedly manipulated emissions. We have 137 million action against Apple regarding alleged misleading advertisement regarding the iPhone's resistance to liquids. And still, in terms of follow-on from Commission decisions, we have a 400 million lawsuit against MasterCard as a result of the settlement decision that the company entered into with the European Commission back in 2014. And we also have a number of cases against as follow-on from decisions by the Portuguese Competition Authority, all in the order of the hundreds of millions. And that, of course, in parallel to some cases that were older and that are running in a number of European countries that are well known to various of you, like the drugs case, which has tens of actions in Portugal, like in the majority of other European jurisdictions. But mainly these class actions in terms of private enforcement is what is most noteworthy in the last year. Finally, in merger control, the Portuguese Competition Authority has been very active with 60 decisions last year, which, considering what was the track record in previous years, is quite a number. But apparently, no complicated decision processes last year, since there was no second phase investigation in none of these cases. And in terms of merger control, the most noteworthy development is the adoption of gun jumping decisions, of which there have been very few in the past. The amounts are still very modest by European standards. We had in 3 cases an accumulated amount of just under 400,000 euros, which is very little. And what is noteworthy in this regard is that in one of these cases, what was at stake is a failure to file a notification on the basis of the market share threshold, which is something that exists in very few European jurisdictions, and that clients legitimately hate. Until now, the big majority, if not all, of the gun jumping decisions that have been taken by the Portuguese Competition Authority were in relation to turnover-based notifications, and there was the expectation that in market share based notifications, since you have to do this previous exercise of defining the market, which is not always obvious, that the leniency of the Competition Authority would last basically forever. And that is proving now not to be the case any longer. And just to end, the PCA has erected as their 2 big priorities for the ongoing year, for 2022. On the one hand, non-poaching agreements. They are looking closely at that. And also at the digital sector. I think that they will be looking very hard to try to find a case in the digital sector. Whether that's possible or not remains to be seen. And Harold, that was the update that I wanted to bring to the group on Portugal.
Yeah, thank you very much. Very precise and brief. Thank you. Are there questions regarding Portugal? No questions. I mean, from your report, I conclude that the topics at stake in the various jurisdictions are everywhere the same. A lot of private enforcement. We really recently were successful in a court case in Stuttgart, where our client, the federal state of Baden-Württemberg, in the timber case was sued for 450 million euro. I'm sure the other side will appeal, so it's an ongoing matter. And control of the competition authorities in the digital world is also eminent. I think we may have a future group meeting just on this topic, maybe once the European Commission comes to conclusions regarding the Digital Markets Act. Are there any questions regarding Portugal right now? Any other questions left? So thank you, Ricardo, for your presentation. All questions answered already, so perfect. Are there any questions left over regarding the United States or any questions regarding India? So,
well, if I could, maybe I would just make one thing I meant to say at the end of my presentation. Yeah, sorry, I was just going to say one thing I meant to say at the end of my presentation, but I didn't. Is, and this may be obvious to everyone, but I do think it is, given the uncertainties regarding how U.S. authorities are going to be looking at different issues in merger control. And given things like the lack of early termination of the waiting period, and these letters that come out that, these warning letters, close at your own risk. In light of all of those developments, I do think it makes merger review timelines a little bit more uncertain, maybe significantly more uncertain depending on the transaction. And it probably counsels in favor of getting, if you have a deal that you think is going to be reportable in the U.S., getting, U.S. counsel instructed, sooner rather than later. Obviously it's always important to have, wherever you're going to be reporting, to have knowledgeable local counsel. But I think in these circumstances, it's probably, we don't know what we used to, right? We're not as certain as we would have been a year or two ago about how the agencies are going to look at something, but it's I think worth considering that.
Yeah, I think it's always important to instruct antitrust advisors early enough in all jurisdictions. I have the feeling that there is more uncertainty in the US because I see more pull and refile than before. Is this just my personal impression, or is this true?
No, it's true. But pull and refiles have become quite common. I had been, I guess, a little bit lucky with some of my filings, but a client asked me the same question, and I went to Debbie Feinstein, the head of our practice group, and said, "What do you think? Is this, I think they're more common, but maybe I've been a little bit lucky. It hasn't been that bad." And she said, "No, I've had nearly every deal I've done lately has had a pull and refile." So she's, so she was basically confirming that impression that, there have been a lot more.
Yeah,
it really depends on the deal, but if you got any kind of antitrust issue,
You just mentioned Debbie Feinstein, your partner, Debbie Feinstein. I had a pull and refile with her, and she was happy about this because this enabled her to finish the US side of a big transaction in the shipping industry before she became competition commissioner at the FTC. So it has a tradition in your firm that your partners become either competition commissioner or assistant attorney general. And well, we'll see what will happen with your career in the next future.
I wouldn't wait around for that.
Now we have just 4 or 5 minutes, and Marcelo Cagliari and Scott Yu, my co-chairs, and we want to briefly tell you what we intend to do during this year. Hannah sent out an email on the 4 dates for this year's online group meetings. We might have more, particularly webinars, if there are interesting topics coming up for everybody. What we intend to do is to have one of the next group meetings in such a way that there will be daylight in Asia and Australia, so that our Australian colleagues can also participate and do not need to stand up 1 or 2 o'clock in the morning. And I promise them that they can choose a topic. And if this is a topic of general interest, we might group other presentations around this, maybe FDI, because I think a lot of us do FDI and we should cover FDI in this group too. If you have any proposals regarding interesting topics you want to focus on, like digitalization or FDI or what else, private enforcement, then please let us know. We have at least one volunteer, Juan, together with Jonathan, may report on the newest developments in Uruguay, where there will be a new pre-merger filing system. This might also be relevant for you. If you have any other topics, please let us know. We are also thinking about a joint group meeting with the dispute resolution group if we choose to go for private enforcement. Also, you will receive in the next weeks to come, earlier than later, an email regarding the update of the merger control guide of the World Law Group, which we did in 2020. It really urgently needs being updated. We thought it would not be advisable to have a printed version again. This was quite a nightmare last time. A lot of copies left over because during COVID, nobody met other people. People were not able to hand over printed copies, which are normally nice presents. I think, and in addition, there are more and more jurisdictions. We might now be able to cover 99 jurisdictions due to new members, and updates are necessary quicker than later, and then it doesn't make sense to have a printed copy, but rather the electronic version. But maybe Marcelo or Scott, you would like to add something, or maybe some of you have ideas for future projects.
Sure, I think, our idea obviously is now that we're going to be doing this virtually a lot more. We used to have our meetings in person during the conferences, which very few people could attend. So in a way, this is a blessing in the sense that we get to involve more people. But the idea is also to make this interesting and useful. So mixing, for instance, reports on news on countries, but also having some sessions, as Harold said, focused on specific topics like damages claims and how that is changing the landscape around many countries, and having a whole session devoted to a specific topic where we can discuss that. So we're open to suggestions. Some are coming in and we'll be certainly taking those on board. But the idea is, let's not miss out on this, the new medium, a new way of communicating, having these sessions where we can actually see each other and discuss, and always in the future trying to leave more time for debate and opinions. But we certainly hope to be able to use this more frequently. We have the scheduled sessions, as Harold said, and we really look forward to having you guys not only propose topics, but also participate and engage. This is part of what the World Law Group is meeting the people who actually do the work, not only the contact partners who meet more regularly, but us knowing each other, which would make our work certainly easier next time we need to collaborate. So we're looking forward to hearing from you, suggestions, and also having you participate in our next meetings.
Yeah, thank you. Are there any other comments, suggestions, proposals? Or do you, Hannah, have any housekeeping remarks or so?
I do. We are actually launching a new CRM system, which is where we'll manage all of our contacts on the website, and we'll have a couple of other new features on the website. Those will be coming soon in the next couple of weeks, at which point you will have to relog into your World Law Group account and update a few settings. Really easy process to do, but I did want to make you aware of that so that you do continue to receive the most tailored emails for your preferences. We're really excited about that, but be on the lookout in the next couple of weeks for an email regarding that. That will be going to all of our users across World Law Group.
Okay, thank you. If there are no other remarks, suggestions, proposals, or what else, thank you, Hannah, for keeping our group moving. Thank you for the interveners, for Hemangini, Ram, Will, and Ricardo for the presentations. Thank you for the participants, for the newcomers, and thank you very much for your attendance today. Have a nice afternoon, and we are looking forward, Marcelo, Scott, and I are looking forward to meeting you soon again during a meeting. So have a nice afternoon or night or whatever.
Bye-bye.
Thanks, Harold. Bye-bye.
Thanks, everyone.
Thank you.
Bye-bye.
Bye-bye.
Bye. Thank you.
Bye.